And I did start recording, so we will be good to go. So welcome to our training on the Connecticut Paid Family Leave Program. We have a lot to cover today, and in terms of questions that you do have, as Angie said, you can put them in the chat. Since it's a smaller group, I'm also totally open to you unmuting yourself, and we can have a little bit of conversation about it. But before we get into kind of the content, I'll tell you a little bit about myself. So I am Dana Dowdell. I own Boss Consulting HR. We are a boutique HR consulting firm here in Norwich, and we serve clients in Connecticut, Massachusetts, and Rhode Island. And this has been, I think, a big anxiety for a lot of Connecticut employers, and probably will continue to be so over the next year, but I'm excited to talk a bit about the program and hopefully help alleviate some anxieties around the program. But before we do that, as always, there is just a little bit of a disclosure. I am not an attorney, so therefore, if you get sued for any reason, I cannot represent you. I can only give you advice based on what I know. So there's a lot that is going to be coming out about this paid leave program. I think there's a lot we don't know yet. So just keep that in mind. I think employers do want to know, well, what's happening in 2022? And we have a whole year to wrap our arms around that. So there's going to be a lot more information that is coming down the pipeline about this program. So let's dive in. And it's really important to understand, before we start talking about paid leave, what did we have before paid leave? So there's 3 laws that are in place that impact or affect or allow employees to take time out of work for certain reasons. We have the Family and Medical Leave Act, which is a federal law, and that applies to employers with 50 or more employees. We then have the Connecticut Family and Medical Leave Act, and that applies to employers with 75 or more employees. And then Connecticut has a law that has been on the books since about 2010 called the Connecticut Family Violence Act, and that applies to employers with 3 or more employees. So the reality that a lot of employers are facing right now, especially if you have been in that 50 or under market, is you've never had to administer family medical leave. You've never had to worry about Connecticut FMLA. And so with Connecticut paid leave, it is new for a lot of employers in terms of the administration of any type of leave. So hence the anxiety. So what is Connecticut paid leave? And it's very important that we distinguish Connecticut paid leave from Connecticut family medical leave. So I want you guys to think about it as it's 2 trains on 2 separate tracks that can be running at the same time. So Connecticut paid leave is very different from Connecticut FMLA, federal FMLA, and Connecticut Family Violence Leave Act. So Connecticut paid leave provides paid leave for certain events that are covered under federal FMLA, Connecticut FMLA, and the Connecticut Family and Violence Leave Act. So who is subject to Connecticut paid leave? Anyone that has 1 or more employees. So if you are a Connecticut private employer and you have 1 employee, you are subject to the provisions of the Connecticut paid leave program. And there are some exceptions in terms of who is not a covered employer. So if you are a unionized employee of the state of Connecticut, or an employee of the federal government, or an employee of a municipality or local board of education, or a non-public elementary or secondary school, you are not covered by the Connecticut paid leave program. However, it can be collectively bargained. So a union can bargain on behalf of their members to participate in the paid leave program. And in terms of your workforce and who would be eligible to take some type of benefit under the paid leave program. So this has come up a little bit in terms of, what if I have employees in different states, or what if I have employees that live in different states? In order to be eligible for the paid leave program and to have to contribute towards the paid leave program, the employee must work for a Connecticut-based employer. They do not necessarily have to live in Connecticut. So if you have employees that live in Rhode Island but commute into Connecticut, they are required to pay into the program. In addition, they have to be currently employed by a Connecticut employer or have been employed within the last 12 weeks. So there's a lot of, layoffs happening still and furloughs. So maybe they're not currently employed, but if they were employed within the last 12 weeks with a Connecticut-based employer, they would be eligible for benefits and be considered a covered employee. There is no way for an individual employee to opt out of the program. So if you have an employee that comes to you and says, well, I have a really robust short-term disability policy, or I don't want to participate in this program, there's no way for an individual employee to opt out of the program. So that's really important to know, no matter where they live. If they earn wages in Connecticut, they have to pay into the program. And there's a lot of unknowns again still about this program, but I want you guys to kind of think about it in terms of how the unemployment system works. So in terms of eligibility to claim benefits, they have to work for a Connecticut-based employer, and they either have to be currently employed or employed in the last 12 weeks by a Connecticut-based employer. And then there's also a wage component to it. So it's not based on how many hours an employee works or how long they have necessarily been employed, but it's based on their amount of wages that they've earned in what's considered the base period. So very similar to the unemployment system. And in order to be eligible for benefits, what will happen is the paid leave authority is going to look back at the base period, which is the first 4 of the 5 most recently completed quarters. And it's going to look at the wages that an employee has earned during those quarters. And in order to be eligible for benefits, they need to have earned at least $2,325 in that base period. And wages do include salary or hourly pay if someone was on vacation, earned tips or commission, severance pay. Those are all considered wages when determining the employee's base period. So how much can your employees take? And I think, this is a big concern over employers or for employers, because for an employer with 1 or 2 employees, having part of their workforce out for up to 12 weeks can be detrimental to their overall business operations. So the maximum amount of leave that someone can take under the paid leave program is up to 12 weeks of paid leave. And if there's any situation or a circumstance where someone is incapacitated during a pregnancy, they can get an additional 2 weeks of leave. So it actually very closely mirrors the leave allotment under the Connecticut Family and Medical Leave Act. The total amount of leave that someone can take in a 12-month period is 12 weeks. So you're not going to have circumstances where an employee can take, 24 weeks of leave. It's 12 weeks within a 12-month period or 14 weeks within a 12-month period if there's a situation that comes up where there's incapacitation due to pregnancy. So if you've never had to administer family or medical leave before, these reasons are going to be new to you. but the paid leave program, again, closely mirrors the federal FMLA and the state FMLA. So if you've had 50 or more employees and you've had to administer a leave of absence under FMLA, these should sound familiar to you. So the qualifying reasons that someone can apply for benefits under the paid leave program is the birth of a child. So that's, you know, a pretty clean and easy one. The placement of a child with the employee through foster care or adoption. They can also take leave or apply for paid leave to care for the family member of that employee if that family member has a serious health condition. And, you know, serious health condition can sometimes be a vague definition. It has to be some type of ongoing medical care issue that results in someone's serious health condition. So I was having a conversation with someone this morning, and they were talking about their aging parent who can't be left alone. That may not necessarily be a serious health condition that requires their care. There has to be some type of serious health condition going on. An employee can apply for benefits under this program if they have to care for oneself. So if they have a serious health condition that's ongoing, they can also take or apply for leave to serve as an organ or bone marrow donor. In situations of family violence, they can take up to 12 days of leave under this program. And then also to take or to care for an immediate family member if that immediate family member is injured during active duty, or some other reasons related to when a family member is called to active duty. So if you're familiar with FMLA, we call that extingency leave. And that the extingency leave does have a greater leave allotment, and traditionally it's up to 24 months if you're taking leave related to when a family member is called to active duty. So there's some nuances to leave when it's for that reason. So this is kind of a pain point for a lot of employers, is the definition of family member. And, you know, what's stopping employees from saying that my boyfriend's mother, who I've been dating my boyfriend for a month, isn't an immediate family member? And, you know, it depends. My favorite consultant answer is it depends. Under the paid family leave program, a family member is defined as a spouse, a sibling, a daughter or son, grandparent, grandchild, or parent, or an individual related to the employee by blood or affinity, and whose close association to the employee shows to be the equivalent of those family relationships. So domestic partners would be covered under the paid leave program. Situations where maybe you have an aunt that is caring for a niece or a nephew, those might be covered family members under this paid leave program. There's a legal term that we have when we're looking at FMLA. It's called in loco parentis, so essentially like a parent. And again, each circumstance is going to be different. So, you know, as an employer, you're going to have to do your due diligence to ensure that an employee is taking leave for an actual family member. And we'll talk a little bit about the administrative process a bit more towards the end. So how much can your employees earn when they are out on leave? And, you know, I have the same feelings about this as I do when someone asks, how much can my employee collect on unemployment? It's like a Tetris game, and it's quite complicated. So the maximum benefit or the employees can earn up to 95% of their base weekly earnings. Okay, so 95% of their base weekly earnings. And the maximum benefit is going to be 60 times the minimum wage. So, as Connecticut inches up towards a $15 minimum wage, the maximum weekly benefit is going to be $900 a week. But that's going to change as we inch closer to that $15 minimum wage. So here's just an example that actually comes from the paid leave authority in terms of how much an employee could earn on the paid leave program. So if you have a full-time employee that's earning $20 an hour and working 40 hours a week, their base earnings would be $800 per week. So 40 times 20, $800. So if we're looking in June of 2023, when we have fully phased in the $15 minimum wage, they earn 95% of their first $600 in earnings, which is going to be $570, plus 60% of their next 200 earnings, which is $120. So in total, their weekly benefit that they could earn from this paid leave program is $690. So the formula itself is 95% of the first, basically the first minimum wage maximum. So in 2023, it's a $15 minimum wage. So 15 times 40 is $600 per week. So 95% of that. And then 60% of any amount above the minimum wage. And I think one question was there a question? I'm sorry. Did I hear anything? No, okay. One question that's going to come up and what I see a lot of employers doing is if they've had to administer family medical leave, they have required their employees to use any accrued time while out on leave. They don't want employees to take, 12 weeks under FMLA unpaid and then come back and have a lot of time on the books. And so this is going to be an area where employers will want to look at their policies because the paid leave authority has specifically responded to this in terms of how the paid leave benefit interacts with any other paid leave program. So paid time off, vacation, sick time. So paid leave authority has come back and said that benefits can be earned. So paid leave benefits can be earned in conjunction with any employer benefits. Okay. So if you have an employee that is taking a benefit from the paid leave program, they can supplement that with their paid time off, but it cannot exceed 100% of their regular compensation. So if you have an employee that has taken some hours of paid time off and their benefit from the paid leave authority puts them over 100% of their regular compensation, the paid leave authority is going to want to prorate their benefit so that it's not any more than 100% of their regular comp. Paid leave authority has recognized that, they're not trying to incentivize employees to apply for this benefit. They don't want to make it better for employees to be out on this paid leave program than it would be for them to work. So they do understand it cannot be it cannot exceed more than 100% of an employee's regular compensation. But paid leave cannot be earned when you have an employee that's out on workers' compensation or unemployment benefits or any other state or federal benefit that provides wage replacement. So it's very clear they cannot collect workers' comp and collect paid leave. So can an employer require their employees to use paid leave concurrently with Connecticut paid leave? And yes, they can, but they have to allow the employees to retain at least 2 weeks of vacation leave or the equivalent time off. So you can't, you're going to have to rewrite your policies. If you have a policy that says you have to use all your accrued time, to account for this requirement that employees need to be able to retain up to 2 weeks of vacation leave or equivalent time off. So there is an exemption to participating in the paid leave program. And what I will say from sitting in on some of the trainings that the paid leave program has put in place is they're really trying to push employers to participate in the state-run paid leave program. There's a way to apply for an exemption if you have a private plan, but it's tricky and it's complicated. So if you are going to apply for an exemption for offering a private plan, the private plan must offer at least the same benefit that the state plan would be, and it cannot cost any more than the state plan. So if you decide that you want to try to roll out a private plan, it has to be at minimum the same benefit and cannot cost any more than the state plan. If you decide to do that, you can deduct from your employees' wages the equivalent that you'll be deducting from their wages for this state plan, but you're not required to do so. And kind of the kicker is that all employees must vote in favor of a private plan. So you have to have your entire workforce on board with a private plan before just rolling it out. So one of the questions that came up from someone who I don't think could attend was short-term disability policies. So this person offers AFLAC to all of her workforce, and AFLAC provides a short-term disability policy if someone is out of work for medical reasons. And if you offer that short-term disability policy, does that count as a private plan? And the Paid Leave Authority has come back and said, no, it does not count as a private plan because, well, it's two reasons. So short-term disability does not cover all the reasons that the paid leave program covers for reasons to be out. So short-term disability policies do not traditionally pay out benefits if you're caring for a family member. And there's no exigency benefits under a short-term disability policy. So I'm glad it wasn't my dog. I thought my dogs were going to go wild today. So it does not count in terms of covering all the reasons why someone would be out. And it also does not tend to pay the same level of benefits as this state-run program will be offering. So yes, your employees can still, purchase a short-term disability policy. You can still buy a short-term disability policy for your employees, but it does not take the place of a private plan, and it does not satisfy the requirements of a private plan. Are there any other questions on that maybe we can address or answer? Okay. So where do you go if you have a private plan that you want to administer and you want to apply for an exemption? One thing that I will say is that the Paid Leave Authority has done a really fantastic job in their marketing and their website and their information materials. And so if you want to apply for a private plan, you would go to ConnecticutPaidLeave.org, and you're going to scroll all the way down, and there's going to be a section that says, I want to apply for a private plan. And you're going to have to talk about, who's the broker for that plan? What is the benefit for that plan? What does it cost employees? There's a lot of pomp and circumstance associated with applying for a private plan. But there is a way to do it. So you'll want to go and start that process sooner rather than later if you want to apply for a private plan. So what's coming right around the corner? January 2021 is when the leave or the program officially kicks off. and it's kicking off with an employee contribution. So one of the nice things about this paid leave program is that it's not costing the employer anything in terms of payroll deductions or a payroll tax. The program is entirely funded by an employee contribution. So effective January 1, 2021, employees will begin to see 0.5% of their paycheck deducted, which will then be contributed to the Paid Leave Authority to fund this program. So in terms of the timeline, it's the first paycheck on or after January 1, 2021. So you'll have to look at your payroll calendar and figure out, what's my first pay date in 2021, whether you're on a weekly or a biweekly pay. And the contributions have to be deducted for every employee as long as you have one employee. So essentially all your employees will start to see this deduction coming from their paycheck. And as an employer, it's your duty and obligation to remit those contributions to the state of Connecticut and the Paid Leave Authority. And so, it's going to be a little bit of growing pains and setting up the linkages to pay these contributions. So your first quarterly contribution will be due on March 31st, but employers do have a grace period of a month to remit their first quarter payment. So the deadline or kind of the hard line for employers to submit their first set of contributions is April 30th, 2021. And just some like nuances, if you're running into situations where, do I round up, round down? Paid Leave Authority has said round to the nearest whole penny, round up to the nearest whole penny. So very similar to how you do like your sales and use tax, just round up. Employee contributions become a permanent part of the trust fund. So it's not like Social Security where you're contributing to it the duration of your employment, and then when you retire, you get that money back or part of that money back. The contributions are not tied to a particular employee, so there's no reimbursement if an employee never takes leave under this program. So that might be tricky or hard to swallow for some of your employees, that they're going to be contributing to this program and may never ever take the benefit. And then the contributions are currently capped at the Social Security contribution limit, so which is approximately right now $137,700. So if you have any high wage earners, they're not necessarily contributing more to the program because it is capped at that Social Security limit. But for many of your average wage earners, it'll be a minimum contribution. So what do you have to do now? If you haven't already, you want to make sure that you register your business. So again, you go to Connecticut or ctpaidleave.org, and about midway down the screen, you will see a button that says register your business. And you'll need to prepare or have your EIN ready. They'll want to know what your annual payroll dollars are. And then you're also going to need to designate a point of contact who will be administering leaves. There's a lot more to come in terms of like the process and how leaves will actually be administered. But they want to know who within your company will be administering leaves. And if you use a third-party payroll company, there is a way to connect a point of contact through this registration process, especially if your payroll company is paying your withholdings on your behalf. So step one and kind of most immediate is you want to register your business. Don't wait until January. You want to register your business as soon as possible. And then it's also important to start having conversations with your employees now. So I have a client where we had a call last week with their employees just to kind of give them some insight into what's coming down the pipeline, so that they're prepared and they know and they can start planning. It's also helpful to start communicating the payroll deduction. There's no legal requirement to tell your employees that, starting in January, you'll see 0.5% coming out of your paycheck. However, that's good employee relations. So when you can tell them, heads up, you will see an extra line in your paycheck, it's 0.5%, and here's what it's going for or going towards, that just helps, improve communication within your organization and trust amongst your workforce. And then starting in July of 2022, there is going to be a requirement to provide written notice regarding employees' rights under the Connecticut Family Leave Act and the Connecticut Paid Family Leave Program, but that's not happening until 2022. So it is kind of strange. There's no legal requirement really for any communication until we get to 2022. But again, from an employee relations standpoint and from an HR standpoint, it's a good thing to start having conversations with your employees now. So some key dates for employers to be aware of. November 1st, 2020 was when the employer registration opened. So you can, again, go in and register. And then January 1, 2021 is when the withholdings from employees' paychecks will begin. March 31st, that's the first payment is due, and then accordingly through the end of the year, the other payments are due. Your employees can actually start to apply for benefits in November and December of 2021. So you will want to start at least having those conversations middle of 2021 so employees know what's coming. And it's not going to be, it's likely going to be your employees who are having babies and who know that they're delivering in early January and maybe want to get ahead of it. But they can actually start applying for benefits at the end of this year for January 2022. So this is my my hope of adding or alleviating some anxiety for Connecticut-based employers who just are worried that this program is going to be, a mess. I work with clients in Rhode Island and in Massachusetts, and the Paid Leave Authority here in Connecticut has said already that there is going to be an administrative process for employees to take leave. So, there will be an opportunity for an employer to respond and say, yes, this is a valid reason for leave, or no, that employee has never worked for me, or, that employee is on workers' comp, not eligible for benefits. And Connecticut Paid Leave Authority has actually said that they are very closely, they're working closely with the state of Massachusetts, because Massachusetts is just about to roll out their program where employees can actually take benefits. So just some, lessons, I would say, from our neighbors. So Rhode Island has a temporary disability insurance program. They also have a temporary caregiver insurance program. So employees can apply for benefits if they're out of work for themselves or out of work to care for an immediate family member with a serious health condition or a serious health circumstance. And there's 4 weeks of benefits there. So they have a much lower benefit period that employees can collect. But Rhode Island has a very good administrative process. So an employee has to file for benefits. And the employer has an opportunity to respond and say, yes, this is a valid reason for leave, or no, this employee is not out of work. And there's an appeals process as well. there is a very robust administrative process. And then also same thing with Massachusetts. So Massachusetts started to have employee withholdings in 2019. And then starting in 2021, that's when benefits will actually start to get paid. And they as well have an administrative process to ensure, fraud and abuse are limited. Now, what I will say is we all employ humans. And, if there's a way that employees are going to be incentivized to take time out of work, I can guarantee you that they will, because we employ humans. So Connecticut Paid Leave Authority has said already, yes, there will be an administrative process. There will be a way to report abuse or fraud or questionable claims, and there will most certainly be a way for the employer to respond as to the validity of a claimant's claim. So very similar to our unemployment process here in Connecticut, where you have an opportunity to address an employee's claim, you will also have the opportunity to address an employee's claim under this program. They will also likely be auditing it, very similar to unemployment. So to ensure that someone is not earning benefits greater than what they should be earning. So it does create a little bit more administrative burden on the employer that you just want to be prepared for and kind of think through from a staffing standpoint, who's going to be responding to those inquiries. Do they have the appropriate access to the information that they would need in order to respond to those inquiries? But I think, we likely won't start hearing much about the process per se until the summer of 2022, or I'm sorry, 2021. The Paid Leave Authority does have some things that they need to work out still, but they will absolutely communicate that to employers.
I'm a little confused as to the administration of the leave. How is the employer involved in that? It doesn't appear that they don't have a financial stake in it. So what is our involvement in determining whether a person is eligible or not eligible?
Well, and so you're not going to be the one necessarily determining whether or not an employee is eligible or not eligible. What you will be contributing is whether or not the employee is out of work, whether or not they are, actively working, if it's a workers' comp situation. The Paid Leave Authority is going to be the decision maker in terms of whether or not someone receives benefits, but the employer is going to have an opportunity to say, yes, the employee is on a valid leave of absence, or no, that is a workers' comp leave of absence. And then the Paid Leave Authority will take that information and determine yes for benefits or no for benefits. And I think that that's actually a really good segue, because one of the questions that has come up is, how does the Connecticut Paid Leave Program and Connecticut FMLA interact? Okay, so previously FMLA and Connecticut FMLA, they were not paid leave programs. So not all they offered, but what they provided employees is job protected leave. So if an employee was eligible for leave, they could take up to 12 weeks of job protected leave from work to address a wide range of situations and circumstances, and have their job held essentially. But it never provided any compensation to employees. And so one of the major questions that has come up is, does the Paid Leave Authority, or does a situation where an employee claims benefits from the paid leave program, provide them job protected leave? And when you look at all the marketing material that the Paid Leave Authority has put out, they are very clearly saying, no, Paid Leave Authority does not provide any type of job protection, any type of job guarantee that if an employee collects this benefit, that they're entitled to have their job back when they're ready to return to work. However, the passage of the act, which is, it's called an act, I think it's, the official term is an act concerning paid family leave. That act has actually amended the Connecticut Family and Medical Leave Act. So in January 2021, there is going to be some type of job protected component. And there will likely be more to come. And again, I think we want to wait until we get a little bit more guidance from the Paid Leave Authority. But what the amendments to the Connecticut FMLA look like is it amended the definition of an eligible employee. So previous, an eligible employee was someone who has been employed for at least a year and had a certain number of hours that they have worked. The amendment to the Connecticut FMLA law.
With the national catastrophe team.
I'm gonna
the office in a return on Monday, November 30th. I understand that you.
Okay, thank you. So it has changed the definition of an eligible employee. So for someone to take job protected leave under Connecticut FMLA, starting in January 2021, they only have to have been employed for at least 3 months. And it has also changed or amended the definition of an employer. So previously it was employers with 75 or more employees. And starting in January 2021 or 2022, it is an employer who employs 1 or more employees. So there is going to be some job protected leave component, which is going to be really tricky for employers to administer. Because if you have never had to administer FMLA either at the federal or the state level, it's not familiar to you. So that being said, all that doom and gloom, what happens next? It's a little bit of wait and see. We are waiting for more direction and clarity from the Paid Leave Authority in terms of how the program will be administered, how do you administer those leaves, any future communication for employees. But what we do know is that in January, the payroll deductions are going to start. So I mentioned this earlier, but the Paid Leave Authority has done a really fantastic job with their marketing and their information. And so that's a great place to start. They have a really robust question and answer section and a lot of resources and tools for employers to prepare for the rollout of this program. But you do kind of have to sit and wait because you're not going to technically have any employees taking leave or applying for leave until 2022. But I would absolutely check out the Paid Leave website because again, it's robust and really addresses a lot of the areas that employers might have concerns of before the leave actually rolls out. And with that, I will open it up to any other questions or things I didn't cover.
Okay, does the Leave Act take into consideration the hiring of people to cover that leave? So if someone goes on leave for 12 weeks, I hire somebody for 12 weeks.
Mm-hmm.
That person comes back, they're protected. I lay off the person I hired. Is that person eligible for unemployment against my record?
So that person would likely be eligible for unemployment, but it likely would not hit you as a chargeable employer because it was only for 12 weeks.
That's what my question is. So my account wouldn't be charged if I only kept that person on for 12 weeks. If I hired them with the understanding they're here to cover.
Mm-hmm.
Okay. Thank you.
Let me see. There was one other question that we had submitted. that they were receiving conflicting info, that if you employ 50 or more people, you have to comply. And then they've also seen if you have any employees. And so again, this is kind of the tricky component because the paid leave program is 1 or more employees. Connecticut FMLA is currently 75 or more employees. So if you have 1 or more employees, you have to start withholding that 0.5% from the employee's paycheck. For 2021, you do not have to offer FMLA if you do not have more than 75 employees. So it's like 2 trains on 2 separate tracks. 2022 is when those 2 trains get on the same track. And Connecticut FMLA leave is going to run concurrently with the paid leave program. So right now they just stay separate, but 2022 is when they're going to get on the same track. Thanks, Anne, for putting that in the chat. Other questions?
Well, if you guys have questions that come up, certainly email me. I'll make sure that the questions get forwarded over to Dana.
Yeah.
So we have no problem with that. I'm sure that there's going to be a lot of questions as we start going into the new year. So this is recorded. And Dana, is there going to be any slides or anything that we could also send?
Absolutely. I will. What I'll do is I'll send you the slides and then also some really helpful fact sheets that the Paid Leave Authority has put together that you can either send out to your employees or just send out to your designated HR contact. And I'll get those to you, and so you can get them out to all the participants.
Perfect. All right. So no other questions from anybody?
Yeah, the website for registering, that's connecticutpaidleave.org.
Yep, ctpaidleave.org.
I put that in the chat as well, Tom. I'll forward that over to you with the paperwork.
And the only other question, I'm a little confused on the base wages to be qualified for the program is $2,500 per quarter or $2,500 per year?
No, so let me go back to that slide. So the Paid Leave Authority is going to, they're going to use a look back period, and they're going to look at the highest earning quarter in the first 4 of the 5 most recently completed quarters. So they're going to look at essentially from the date that an employee or applies for benefits, they're going to look back 5 quarters essentially and look at that employee's wages in each of those quarters. And if they've earned at least $2,325, then they would be eligible for benefits in a quarter. Does that answer your question?
I believe so,
Okay.
because part-time workers, high school kids earning $2,000 a quarter, they would not be eligible for the program.
If they did not earn that threshold of $2,325, then they would not be eligible to apply, to get a benefit. They could apply, but they're going to get denied.
Okay, thank you very much.
Yeah, it's very similar to, again, how the unemployment system works, where you can't just go and apply for unemployment. But I mean, I'm sure as an employer, it feels like everyone just goes and applies for unemployment benefits. But you have to have wages on the books in order to get an unemployment benefit. And so it's going to act very similarly. Your per diem employees are likely not going to qualify for the benefits because they haven't earned enough.
But they will still be charged the 0.5%.
Correct. Correct. Any other questions? All right. Well, thank you so much for joining me right before lunchtime. That's where you can find me. I am an email away, or you can visit my website, and we will get this recording out and the slides out and some information out to everybody that participated today.
Dana, great job. Thank you so much. Any other final questions for Dana? All right. You're amazing, Dana. Thank you so much.
Thank you.
I'll get all this information out to all of you, and I hope you guys have a very happy holiday coming up. So.